Hello, my name is David Sherriff. For 10 years, I served as Senior Real Estate Counsel in the Cleveland Clinic Law Department, retiring at the end of 2014. I recently returned as a consultant, and I am currently consulting on real estate law matters. In a very general sense, I'm going to be discussing landlord-tenant law in Ohio with you today, with a focus on leasing residential property. These laws vary from state to state, and my comments are intended to be educational and not legal advice. If you live in an apartment or other rental property, you typically will be required to sign a lease, which is a binding written agreement between two parties to establish the terms, rights, and obligations of the parties, applicable to the tenant's use and occupancy of residential premises. Although oral agreements are binding, I strongly encourage you to reduce a lease to writing to avoid any ambiguities or confusion about the rights and obligations of the parties. There are many provisions in the lease which you should be familiar with and which will affect your ability to use and enjoy rented property. Following is a review of some of those provisions. While what I'm about to say goes without saying, I'm going to say it anyway. Thoroughly read the lease before you sign it and make sure you understand each and every provision. Most leases are written in legalese, and there may be some provisions that you do not understand. If so, solicit the advice of a professional to help you understand those provisions. Do not ask the landlord to explain them to you. When reviewing a lease, you should be particularly cognizant of the following provisions. Make sure all the people who will be occupying the premises are identified in the lease. Many leases restrict the number of people who can occupy the apartment or other residential property, so it is important that you disclose all occupants to the landlord. Also, if you are sharing a residential property with others, you should all sign the lease to ensure that each of you is contractually liable to the landlord for the lease obligations. The term of the lease should be clearly set forth with a definite start and end date, and the date rent will start. If there are renewal options, that is, if you have the right to renew the term for a period beyond the initial term, be cognizant of any notice requirements that require you to give the landlord notice, usually in writing, if you desire to extend the term of the lease. Typically, such notice is required to be provided in advance of the original termination date of the lease. If you stay in the premises beyond the expiration of the term and do not exercise any available renewal options, you become a month-to-month tenant, and the tenancy can be terminated by either party upon 30 days' notice. Also, leases may provide that if the tenant remains in the premises beyond the expiration date of the lease, the tenant may be required to pay additional rent during the holdover period. If the lease requires you to give the landlord a security deposit, sometimes 1 month's rent, sometimes 2, understand what it can be used for. Usually security deposits can be used by the landlord to offset the cost that may be incurred by the landlord to repair any damage that may be sustained to the premises during the period of the tenant's occupancy. If the security deposit is 2 months, it is usually to ensure that the last month's rent will be paid and can be used by the landlord for that purpose. Make sure the rent stated in the lease is what has been agreed to by the parties, particularly if there are any rent escalations during the term or any periods of free rent which landlords may offer to induce rentals. Also, understand if the rent includes utilities, and if so, which utility costs. Landlords typically include water usage in the rent, but generally not heat and electricity. Although leases typically do not require the tenant to carry property insurance in the event the building is damaged or destroyed by fire or other casualty, the landlord will not be responsible for any damage to your personal property in the event of such a loss. However, leases will typically require you to carry liability insurance to protect you and the landlord from claims by third parties for damage sustained resulting from things like a slip and fall in the premises. In some cases, a landlord will require a tenant to provide it with evidence that the liability insurance has been obtained as a condition to occupying the premises. You can get what's called a certificate of insurance from your insurance agent, which will show evidence that the insurance is in place. Leases will contain provisions setting forth the obligations of the parties concerning maintenance and repairs. Typically, the landlord will be responsible for maintaining, repairing, and replacing systems in both the building and the premises, such as plumbing and electrical systems. This provision should provide for a specific time frame, usually not more than 30 days, for the landlord to make such repairs. However, some leases provide that if the damage is due to the fault or misuse of such systems by the tenant, the landlord may not be responsible for the cost of such repairs. Also, if the landlord is going to enter the premises, except in the case of an emergency, reasonable notice must be given to the tenant. Most leases will provide that the tenant is required to keep the premises safe and sanitary, dispose of garbage in a safe and sanitary manner, keep plumbing and electrical fixtures clean and operate them properly, comply with all state and local housing and sanitary codes, not destroy, deface, damage, or remove any fixtures, appliance, or other part of the premises, or allow any guest to do so, keep all appliances provided by the landlord clean, and promptly advise the landlord if repairs are needed, and not disturb or allow your guests to disturb your neighbors. Leases will contain default provisions which set forth the remedies of the landlord in the event the tenant does not perform his or her obligations under the lease. The most obvious default by a tenant would be to not pay the rent when it is due, and it is important to pay rent by the due date, or if there is a grace period, by that date. If the landlord does not declare a default, if the rent is not paid on time, the landlord typically will have the right to charge an administrative fee and/or interest for late payment. A tenant can also be in default if he or she fails to comply with any of the other lease obligations which I have previously discussed, like keeping the premises safe and sanitary, and using plumbing and electrical fixtures properly, etc. Default provisions will typically require the landlord to give a tenant notice in writing of a default and allow for a cure period. That is, a period during which the tenant can correct the default without being in breach of the lease. If a breach does occur and is not cured, the landlord can evict the tenant. In most states, including Ohio, the landlord must provide the tenant with a 3-day notice to vacate, and if the tenant does not, the landlord must file an eviction action in court to dispossess the tenant. Eviction actions can take as long as 60 days and will typically seek, in addition to evicting the tenant, any unpaid rent and the recovery of landlord's attorney's fees. Leases typically provide that when the tenant vacates the premises at the end of the lease term, he or she must leave the premises in the same condition as when the tenant moved in, ordinary wear and tear accepted. That means that dirty walls and carpets and holes in the walls will not trigger the landlord offsetting any costs of repair or cleaning against the security deposit, because the landlord expects to clean the apartment and paint it for the next tenant. But any damage that might cause the landlord to replace the carpet or a damaged ceiling or appliance may be the responsibility of the tenant. It is also important that all of tenant's personal property be removed at the time he or she moves out, or otherwise the landlord can dispose of the tenant's property. In the event a landlord is not performing its obligations under the lease, in addition to any contractual rights you may have under the lease, in Ohio, a tenant has the following rights: to complain to a governmental agency if the landlord is violating any housing laws or regulations affecting health and safety, to complain to the landlord if it is not performing its lease obligations, if the landlord attempts to retaliate by increasing rent, decreasing services, or evicting you, the landlord has violated the law, and you can seek legal remedies to prevent that from occurring and may be entitled to recover damages and attorney's fees. If you breach the lease, the landlord may not seize your furnishings or possessions to recover rent payments. Unless there are time frames specifically stated in the lease, in the event the tenant notifies the landlord of a problem at the premises, like rodent infestation, etc., the landlord has a reasonable time to correct the problem, which is typically 30 days, unless it is a more critical problem, like the furnace breaking in the winter, in which event a reasonable time may be just a few days. You have the right of privacy, and as I mentioned earlier, the landlord must give you reasonable notice, except in the case of an emergency, to enter your premises. In some cases, you may be able to escrow your rent in the event the landlord is not fulfilling its lease obligations. You are required to provide the landlord with notice of the violation, and except in extreme or emergency circumstances, must give the landlord 30 days to cure the violation before you can start escrowing your rent. The rent must be deposited with a county or municipal court in the jurisdiction where the premises are located. You can only escrow rent if you are then current in your rental payments and were not notified by the landlord when you moved in that the landlord owns 3 or fewer rental properties. I hope this presentation has helped you understand landlord-tenant law. There is a wealth of information on the Ohio State Bar Association website if you have questions or want to learn more. I wish you all the very best in your future professional endeavors.